Hello, my name's Rachel Frost-Smith, and I'm presenting today on managing litigation and post-separation abuse tips and tricks for practitioners. I'm a family law practitioner, a legal director in a Legal 500 firm. I practice across all areas of family law, divorce, finances, and children. And as part of that, I represent people who are the victims of domestic abuse and also those who've been accused of having perpetrated domestic abuse. As those of you who work in this area will be aware, since there's been a withdrawal of public funding, there are many more litigants in person in the area in which we practice. That being said, sometimes, and I shall talk about this later, some people choose to represent themselves in order to behave in a particular way during litigation. So litigation that I'm referring to would be financial remedy proceedings, private children law proceedings, Family Law Act proceedings, so occupation orders, non-molestation orders, interim applications, any form of application really that we might come across in our practice. The final sort of general introductory comment I'd make is that I think this area has really changed profoundly in the last 10 to 15 years. I remember a long time ago doing some research about whether or not it was recognised by practitioners, by the judiciary, as to whether or not people would use litigation as a form of post-separation abuse. And at the time, there was a lot more research on this in the US. And people who'd been interviewed, who'd been involved in proceedings, said that they'd often been informed within proceedings not to raise abuse because it could make the outcomes worse for them. Now, thankfully, that has changed profoundly, and the changes that have taken place have been in the law. And we'll talk about the Domestic Abuse Act 2021. We'll talk about PD 12J. And also hopefully in mindset of what we understand now as people, as humans and practitioners about abusive behaviour.